It's noon. This is the webinar Understanding Contracts. I'm Bill Petrovic. I am the person responsible for webinars and conferences at the SCORE chapter in Indianapolis. We try to do a couple webinars a month on topics of interest to small businesses. The SCORE chapter in Indianapolis, if you don't know, is a group of all volunteers. We do both mentoring and workshops, webinars. We have over 50 members in our chapter. We do mentoring throughout the week, Monday through Saturday. I know that when you receive the publicity for these webinars, you also get an opportunity to sign up for mentoring, and I would encourage you, if anything today comes up that you're interested in discussing further, we can set up a mentoring session as well on this or any other topic. So our speaker today is Ed Lichtenstein, and Ed is a retired attorney working in the area of corporate contracts throughout his 30-year career. So he's done it all. He's drafted, he's negotiated, he's administered, he's closed out, and he's settled disputes that can arise when there is a contract. So he's done it all. He's worked for engineering companies and construction companies involved with contracts, joint ventures and partnerships. And we're glad that he's here to share what he's learned. Since Ed retired, he has been a SCORE mentor and has been in some leadership positions in the Illinois, Chicagoland area. We're going to use his slides. He's going to take it over and talk. But one of the things I wanted to mention is that even though we cannot hear you due to your microphone being muted, we would like to ask you to deliver questions through the Q&A feature that's in Zoom, and also right now through the chat feature. Introduce yourselves. Just type into chat your name and say hello and mention a few words about what you're hoping to learn today. And everyone should be able to see those chat messages. And that'll sort of serve as our introduction here as Ed gets started. So like I mentioned, we're going to go till about 1:30. And as we go along, feel free to ask questions with Q&A. And don't be bashful about using the chat right now to say hello to the group and mention any items you hope we covered today. So Ed, I'll turn it over to you, and thanks for working with us today on this.
Okay, thank you. Good morning, everybody. Or I'm in this morning, you're now in afternoon. I'm going to go through a little bit of introduction while some of you are writing out what you expect from here. And then I'll ask Bill to read off maybe 4 or 5 selected random ones, and that'll give me an idea of what it is you wanted when you came to this, so I can start maybe just to answer those questions. Bill can interrupt me anytime during the course of this, and when he asks with a question that you may have submitted, and at that time I'll either answer the question, I'll say I don't know, but I'll get back to you, but I should know, or I'm going to cover that a little bit later on, and we'll do that then. So that's the way we're going to go for the moment. And now it's
okay. So we're getting some good comments in here. Shannon is curious on how to create contracts. There's
Right.
Scott interested in prime vendor contracts and how enforceable they are.
My screen froze. Let me see if I can get back to it.
Oh, okay, I'll keep going here.
It's not what I was looking for. There we go.
Takesha, I'd like to understand and develop business contracts with risk control.
All right, I'm back. Am I sharing again?
Not yet.
Okay, let me get to sharing.
Approving contracts with clients, contracts with employees. There we go. That little
There we go.
technical glitch.
Am I on?
Yeah,
Okay.
yeah.
Okay, so Bill took care of really the first slide. I worked for over 30 years in contracts for major international E&C firms and original equipment manufacturers, dealt with people all over the world. And before that, I was a teacher and high school administrator, so it's somewhat varied. Down below, you can see my contact information. If you have a question, you can contact me at that email address or at this phone number. And if you try any other phone number, find another phone number for me. I won't answer because I won't recognize the number. Okay. Bill's asked you to do this, and I really do want to know what you want from the workshop, simply so I can frame what it is you're talking about or what you're concerned about. Now, the title of this is a little bit different than what you expect in contracts. And that is because I'm not going to talk really about it as a legal document. For today's takeaways, I want you to think about a contract as more than a set of legal terms and conditions. It's far more. It tells you what it is you've got to do. It tells you what has to happen. And it's more than just the terms and conditions. Now, you should be able to take away some ways to make the contract work for you. It's not a document that you sign and your customer or your supplier signs and you put it away. It's something that works for you and helps protect you, or can help protect you. Think of the contract as a work order, rather than just a set of legal terms and conditions. It's something that tells you what you have to do and what your obligations are. And finally, we'll talk about how to identify the risk you are taking. And we're going to talk about why we talk about risk and how they can be either eliminated, mitigated, or accepted. Okay, Bill, have we got any random ones we can read off of what people are expecting?
You know, the big overriding thing is interest in the basics, you know, just the very fundamental thing about contracts. How to write them, what you need them for, that sort of thing. Especially, more than one person mentioned they're just starting their business, so they haven't had much experience in this, but they know it's a weak spot that they want to make sure they don't overlook and can handle properly. So
Okay.
I think the basic blocking and tackling, the fundamentals of contracts is really the overriding wish that people are coming to us with.
Okay, we can handle that. That's okay. First of all, what's a contract? We can't start any more basic than that. It's an agreement among two or more people or organizations. Because organizations, your business can make a contract. It's an agreement to do one or more legal acts. You cannot make a contract for something that's illegal. It's not enforceable. So And as soon as we say it's a legal act, you need to realize one thing, is that very rarely in a contract are you or your customer or your client or your supplier going to be asked to do anything that's illegal. That's not enforceable. It's a legal act based on an offer to do something in return for some form of consideration. Usually, but not always, money.
Hey, Ed, here an interesting question popped up.
Yep.
Does a contract need to be notarized?
No,
Okay,
no, the contract does not need to be notarized. It needs to be signed by someone who's legally competent to make a contract. It needs, so that if you're 20, a minor is limited in what kind of contract they can sign. A fully functioning adult can make any kind of a contract they want. Now, and a bet is not necessarily a contract. The act can be, I will build a house for you, and the consideration is I'm going to pay you money. Or it can be, I'm going to let you use my intellectual property and you're going to pay me money, or you're going to some kind of money, or you're going to give me something else in return. Maybe I'll let you use my intellectual property if you agree to give me space in your building. So it doesn't always have to be money, but it's always for some kind of consideration. A contract is not a promise to do something for free. Okay. What is it practically? And that's aside from the legal agreement. It's an agreement which tell each of the parties to the contract, and they can be 2, 3, 4, 5 different parties to a contract or more. It describes one, what their obligations are according to the contract. And that's an important distinction. It's not what you think your obligations are. It's not what you think the party you're contracting is going to do. The contract describes the obligations each of you are assuming, whether it's the obligation to pay or whether it's an obligation to perform. It identifies when the obligations must be performed. If you're going to deliver X goods by X date, that's one of your obligations. If my obligation is to pay you for those goods or services by a certain date, that's my obligation.
hey, Ed.
Yep.
Here's an interesting question. Does the contract have to be written, or can it be on your website somehow that you can enter into a contract via some sort of a website agreement?
Yes. In fact, when you sign on to agree to somebody's app and the terms and they tell you, do you agree to the terms and conditions, which you know are 14 pages long and written by a lawyer and you're never going to understand? That's a contract. When you say yes, that's you've agreed to the contract terms. You may not ever have read them, but you've agreed to them. Because if you don't sign it, you don't get to use their app. So yes, you can do it. Make a contract online. You can make an oral contract for certain limited amounts of money. And that depends upon the state, how large the contract is before it has to be written. The contracts can be entered into a number of ways, and a contract doesn't have to be labeled as a contract. It can be an MOU. It can be a set of promises. It can be almost anything if both parties have agreed it's legal and its consideration is offered for the obligation. All right. Contract will describe how the obligations are to be performed. It may be you have to meet a certain quality standard. It may be where the contract obligation will be done. It could be what materials you're going to have to use. It could be almost anything. It could be the standard of performance that you're obligating yourself to. It can be a whole number of things. It can be the documentation you have to provide before you get payment. Or it may be the way you have to provide, the format in which you have to provide your deliverables.
Ed,
Yes,
you mentioned MOU. What does that stand for?
it stands for Memorandum of Agreement, of Understanding, pardon me.
Memorandum of Understanding, okay.
Yeah,
And is a service level agreement a contract?
is a service subject to a contract?
Service level agreement. So you have some sort of a paper document with a client that says that you have a service level that you promise. I'll be there within 1 hour if you take on my service, that sort of thing.
Yep. It is, if the contracts, if you have signed a contract which says when the performance will be performed, you should be there at that time. Particularly when it says something like time is of the essence. Usually you may get some wiggle room if you just describe a delivery time or a performance time. If the contract winds up saying time is of the essence, then it says time is a critical element of that contract. And you need to follow it. You can be in breach if you don't match the time.
There was a follow-on question that says, how can I cancel it or get out of it?
The contract will tell you how. And contracts will have termination clauses, or it may have. Now, one of the things that you should be aware of is that a contract is not only what's written in the contract. Many times you are governed by laws which aren't mentioned or which aren't specifically described. You may provide goods under what's called the Uniform Commercial Code. There may be building standards which are not referenced in the contract, but you have to follow anyhow. So there are all kinds of things outside of the written boundaries of the contract, which may apply. And we'll talk about some of those later. All right. And it also talks about 1, 2, 3, 2, 3. I got to fix that. The consequences.
I saw that.
All right. It also will describe the consequences if the obligations aren't performed. And to when, where, and how required, performed when, where, and how required by the contract.
Ed, what's the difference between a proposal and a contract?
A proposal simply says, I propose to do this. I will do this for you. Now, some proposals are written so that if you sign the proposal, it turns into a contract. If you send me a proposal and I accept the proposal without any changes and say, I accept, that can be your contract. If you send me a proposal and I send you a counter proposal, there is no contract because we haven't agreed on the terms. Because a contract is an agreement that says all the parties agree to what's in the contract. So a proposal is what you as a contractor may send. And if someone then sends you money or says in recognition that, yeah, we want this, and they haven't disagreed, you can argue that you got a contract. Now, a contract, let me diverge just a little bit. A lot of companies sign contracts, take the contract, put it to the side, and do what they think they're supposed to do. And they get away with it a lot of the times if the contract is ignored, both parties. However, and it's a big however, if the contract is breached, it's not performed satisfactorily on either side. One bad contract, one bad breach can take your business away from you. It doesn't take a lot. Most contracts get performed without any problems at all. But when you've got a problem, whether a dispute, whether it's over the quality of the product, delivery time, payment, whatever, it can get expensive. And if the contract is clear about what the obligations are, you're going to be, and you followed the contract, you're going to be in pretty good shape. Okay. Now, is the contract just the terms and conditions? Nope. It's far more than that. You'll generally see, all right, here's my general conditions. And people say, okay, I'll agree to that. But there can be more. What else is there? Okay, there can be a payment schedule. What the terms of payment are. And they're different than the schedule. You may say, I'm going to give you payment once a month in 30 days from the date of receipt. Or it may be, I'm going to pay us the terms, and they say payment upon receipt. I may have to submit the payment, some documents in order to get my payment. Or your supplier or contractor may, or service company may have to submit to you certain documents and evidence of work performed before they get payment. There can be a schedule of prices. So, and that can be in construction, it can be in almost any industry. You know, list out, here's a schedule of prices, and that helps you if there are changes coming. Okay. Documentation requirements. Now, in order to show that I have performed the service or provided the goods, am I going to have to provide you documentation? I remember vividly working on one contract. I was working in Canada at the time, and we must have, it was a multi-billion dollar contract. And we obligated ourselves to provide certain documentation in a certain format. Problem was, we didn't use that for the format that the customer required and hadn't priced what it would cost us to provide the documentation in the format required by the customer and the contract. It took us a lot of money and about 7 months to a year to resolve that dispute, resolve that problem, and turning the documentation into what the customer wanted. It can have what's called a scope of work or division of responsibility. My guess is you have probably had a contract where you and either your customer or your supplier you thought you had one thing coming and they provided something else. That's a problem in terms of who is supposed to do what, when, and that's not even schedule. If I'm supposed to give you something before you can complete the responsibility, and I'll use construction as the example, if I'm supposed to make a workspace available to you at a particular time, and I don't do it, I'm in breach. It's going to probably cause a change on the part of my contractor. If I was going to approve your plans or a model that you gave me that said, yeah, this is okay, if I don't approve it by that time, by the time I'm supposed to, that can be a problem. So that scope of work, division of responsibilities really should be very clear, especially if you're doing a very complicated contract. Or it's, I wouldn't say very complicated, if you're doing one that has a lot of moving parts to it. Because there can be easily misunderstandings as to who's supposed to do what, when, and where.
And one thing I want to mention,
Go ahead.
Ed, that I didn't mention at the beginning, and some people have joined us since the beginning, a lot of people, in fact. We are recording this, and we have a YouTube channel for our chapter that shows all of our webinars, and all the people who are on today will get by email a link to the YouTube recording of this particular webinar. So that's just wanted to mention that to everybody. Okay.
All right. Any other, while we're small break, any other questions that have come in?
There was one question. I'm just going to read it literally. I paint portraits, and I'm wondering if some kind of subcontract is necessary once the final painting is approved.
I'm not sure what you mean by a subcontract. Well, if you're doing, this is portrait painting, right?
Yes.
Okay. My guess is it's not a real, now they may be sitting for the portrait, which means they have to make themselves available. It may be a portrait from a picture. Once you've created the portrait form, that becomes their painting. Won't necessarily have any intellectual property rights in the portrait. I can't think of what kind of subcontract you might have.
A question followed up that said they might ask for an adjustment or for alterations.
Okay, that should be covered in the original contract. You can't, that one's really tough because it's a matter of artistic taste. They picked you for your style of painting, and you've got a particular style. If they wind up not liking the way it's done, that's really their problem. That's a problem, and I'm not sure that you can dictate
Yeah.
their acceptance based upon, oh, I like or don't like it.
So, and I think you hit the nail on the head. The client said, great, okay, I'm going to only allow 2 changes, and that'll be in the original contract. So
you can specify that.
That's the solution.
Yeah,
as long as we're on a pause here, there's another good question that says, I send contracts to my customers and they're supposed to sign them and get them back. But what's a reasonable time to expect that to happen? Should I be asking if there's any further questions or what? it's these kind of, these contracts are kind of hanging out there unsigned.
Well, one, I don't know what the product is, but if you're giving them a contract, you shouldn't be performing before you sign it, before the contract is signed.
Right. I
And you
think
don't
that the
want to get
question
to
is
the end
really,
of you don't want to get to the end of the contract, find yourselves in a dispute, and then find you don't have a written contract. If you've
Right.
taken the trouble to draft it or have a lawyer draft it for you, and you give it to your customer, you created it for your protection, and you're waiving your protection. So
okay. And another question, the concept of a one-sided contract. Could you touch on that? That seems to be an issue.
yeah, that's what's called a contract of adhesion. And that's when the parties don't have equal bargaining power. And we sign contracts of adhesion all the time. When you sign that use contract for the app on your computer, or being able to use the program, that's basically a contract of adhesion. You either agree to it or you don't get it. But other than situations like that, it's usually when you're in an unfair bargaining position and you just don't have equal bargaining power, you'll get a break, or it may lean towards you in terms if there's a dispute. But that one really goes more case to case. I can't give you any blanket statements on contracts of adhesion.
Okay.
Now, the law doesn't look favorably on them. That doesn't mean it always rules in your favor.
Going back to the question about waiting for the customer to sign the contract, follow on was sometimes I send them the contract and then they just send me an email and said, I got your contract and I agree. Is it now a valid contract? They sent an email back?
I believe, again, depending upon jurisdiction, it would probably rule yes. Probably. And you got to remember, when it comes to the law, there's almost no such thing as black letter law. It works the same way in every situation. But if they send you back, acknowledge the contract, or say that they agree, you're generally going to be in pretty good shape.
I'd recommend, I'm not the lawyer you are, but I recommend printing that out.
Oh yeah. Important documents, electronic documents are acceptable in courts. Print it out and keep a written file of it. Paper still works. In cases of dispute, it's record keeping becomes really critical. And we always used to say, he who's got the better, more documents, more documentation of their contract requirements usually wins. They don't necessarily always get everything they want, but they usually come out better than the other guy.
Another question. What about contracts that contain a monthly payment requirement, like membership for physical training? Are they considered signed by the customer when they begin making payments?
No, but because that's proof that there's agreement, and it'll usually be enforced. But usually when you've done that kind of thing, the trainer or the physical facility will have had you sign an agreement beforehand. Because what they do is they look to be able to withdraw from your bank account. But you're starting to pay and receive services, even without the signed document, is going to be considered proof that, yeah, you consider that there's a contract. Does that answer the question?
I'll find out if they follow up, but sounded good to me.
Okay. All right, as there's more on the contract. There can be a work schedule. There can be different specifications and drawings. And that is, with specifications and drawings, you can provide your supplier, your customer, with specs and drawings of what you're going to do, or you may be provided with specs and drawings. And if you are, take a look and make sure that, take a look at them and make sure that they're consistent. Frequently happens that the written specification may not agree with the drawing. And you should look to get them done, or else there should be what's called a order of priority in the contract, so that you know which one you can depend upon. Because at least in construction, the specification and the drawing may have been written by two different groups or two different people who didn't bother to talk to each other or have the other review their work before it goes out. But you as the supplier, or you as the builder, or you as the receiver, the customer, may not have noticed that. But you're going to be the beneficiary, the victim of the inconsistency. A contract can have all kinds of appendices, exhibits, reference documents, or talk about what the applicable laws, codes, and standards are, but they may not be in the contract except by name. In the construction business, one of the frequent tactics of a prime contractor is to say, I'm going to included in your contract are the terms and conditions of my contract with my customer. But then they never show you what that contract is. So you don't know what you're working to. So you should identify, at least for yourself as a contractor, a supplier, whatever, if what those appendices, exhibits, or reference documents are, and make sure the applicable laws, codes, and standards are done. One of the things that happens frequently is during the course of a contract, a law may change, or a new code may change. So you not only want to apply the laws in effect at the time of the contract, give yourself a grandfather clause, or a certain addition of the codes and standards, so that if they change and if the customer requires a change, or the new law or new code and standard requires that you change, that can cost you money. And you want to be able to get paid for that change. And so if you're specific in your contract as to what applies, you've got arguments, you've got room to argue for the change. And there can be something that's called special conditions. And it may be so they may term something else, which says, for this contract, general condition number XYZ is modified to read. So you need to know that. Just reading the terms and conditions itself and knowing what it is they're supposed to do is not enough. Okay. Now, unless something is specifically stated, as otherwise specifically stated, any change must be done according to the requirements of the contract. If say you're remodeling your home and your contractor comes in and says, well, I need, not your contractor, let's say you say, or your wife says, or your spouse, whatever, that I want a cabinet here instead of over there. The contractor is going to look to make a change for you and charge you for the change. You should have the contract should say how that change is going to be done, how it's going to be priced, how it will affect schedule, how it's going to affect your terms of payment. You as a customer getting your kitchen fixed or your bathroom fixed need to know the impact so that that project which you and the contractor agreed that's going to cost me $3,000. All of a sudden you don't wind up with an unexplained charge that raises it to $5,000 simply because you told him to change it. And he said, sure, I'll do that, because the contract wasn't specific enough. If there's changes need to be done according to the requirements of the contract. If they say that if you want to change, okay, tell me how much it's going to cost me. Tell me what it's going to do. Or if your customer asks, here's what it's going to cost you. So you don't want to get into an argument afterwards. Okay. Now, contracts are essentially risk management tools. And that's probably not the way you've always thought about it. Remember, originally I said that you're rarely, if ever, going to be asked to do anything illegal. And if you're asked to do it illegal, you can't legally perform it. But what it is, a contract covers risks. And that risk is something in that something will happen that any one of the parties to that contract may not be able to do, or willingly fails to do it because it cost them too much to do it. All right, and that failure will impact the cost, schedule, or value of what's supposed to be done. So what you're trying to cover in the contract is the risk, one, of your having to perform it, or the risk, if you're on the receiving end, the risk that it won't be done. And what happens when it's done.
Here's an interesting question that I think you've stimulated with your comments. When providing a service as a product, is it necessary for both the buyer and the seller to have a contract that's considered, or should only the seller have a contract that protects and benefits both parties? It's kind of like, oh yeah, I'll sign your contract, but here's my contract. You sign my contract, and now let's get started.
And if that happens, you're going to have all kinds of arguments. A contract is really, remember, a contract has got to be an agreement. So if you can't agree to what the contract's terms are, you arguably do not have a contract. So that means you're going to wind up negotiating. If you're, let's say for the moment that you're selling your service to a major company, and the company presents you, okay, here's the terms under which we'll buy your service. You can be guaranteed that they've written that contract, or they've had the contract written in such a way that they are protected to the maximum possible extent. because some nice lawyer's done that and they paid the lawyer a lot of money. On the other hand, if the contract you may present, if you've done it yourself, I'll guarantee, and you're not a lawyer, I'll guarantee there are holes in it. If you've had a lawyer do it, the lawyer's done for you, hopefully, what the lawyers have done for the major company. The lawyers protected you from the risks. And you got a choice as the provider or as the buyer. Are you willing to change the risks that you take in what's called your pro forma, your standard contract? And what will it cost you to, what will it take for you to assume greater risk in your contract? And that's why I call your contract a risk management tool. Is some kind. All right, let's take a contract that says, when we used it for, you've taken a contract that says time is of the essence, which contractually means that you have to strictly adhere to the timetable of the contract. Are you willing? Can you truly perform that in that time schedule? Have you, or is there a chance you may be late, and you don't want to be held to the standard of time of the essence? There may be a risk, a mitigation strategy in that you create a schedule that gives you what's called float. You're not going to do a just-in-time schedule. You're going to do a just-in-time plus some extra time, because even the most simple contract, something can go wrong. In almost every contract I've signed or negotiated with, we build in float. We build in that extra time just to make sure that we can do it. Or we do something else that says will help us curtail the risk. So what you're doing is using the contract so that if there's a failure that affects the cost or the schedule or the value of what's being bought or what's being provided, you're covered. All right. Did we answer the question about that person about whether that you signed two contracts or not?
Yeah, I think that your point, as I understood it, is no. There should be one contract that both parties are happy with.
Yeah, you got to do it. You're going to make compromises in a contract, and there's unless you've got an absolutely standard product that you're not going to change for any reason whatsoever, you may wind up in negotiation.
Ed, that kind of reminds me, maybe this is more of a tactic, but usually when there's two parties involved, one or the other has a contract ready to go.
Oh, absolutely.
And so that person takes the contract and slides it across the table to the other person and says, here's the contract, go ahead and sign it, and we're in business. What do you advise in terms of how somebody should handle that as far as reviewing, modifying, changing, negotiating, that actual physical activity that they go through, or should people just say, I want this this activity so badly, whatever it says, no problem, I'm signing.
Okay. Only if you are absolutely sure of yourself or desperate should you sign a contract that you don't know what's in it. And if someone has got a prepared contract, they've probably had at least one attorney prepare it for them, it probably has not been written to be straightforward. It's got different parts, different obligations buried in other parts of the contract. You may find yourself in for surprises. It's like referencing a document you just didn't know existed, or bind you to the terms of another contract which you just haven't been provided. If you're sitting there and someone says to you, "Here's my contract, sign it," your answer should be, "I need to read it first. I need to understand it." If they say, "No, you've got to sign it now," and signing, sounding like some of the timeshare people to say, "No, you got to sign the contract right now because this offer is only good today while you're here." Be suspicious. Right? Read it. Make sure you understand it. Know what your obligations are going to be, whether you're the buyer or whether you're the seller. If you're given a standard contract and they're said, "Here, you got to sign it because the offer is only good for the next 10 minutes. Be suspicious. And when I went to law school, I, of course, like everybody else, took out loans to finance it. And the loans that I got hadn't quite come through the first day that I went down to law school, so I had to sign a promissory note. And I wouldn't sign the promissory note until I'd had a chance to read it. I knew I was going to sign it anyhow, but I wanted to know what I was signing. And I think I gave away everything but my firstborn if I didn't make the payments. But I at least knew what it was I was signing. And then I made a risk choice and said, "Okay, my loan has been approved. I'm going to have the funds. It's going to come through. I can sign this." But if the loan hadn't been approved, I didn't know where it was going to be, I might have made a different decision. So it's important, and it's for almost everything. Know what your contract says. Know what you're agreeing to. There's going to be situations where, yeah, I'm going to have to take that risk, but you're doing it knowingly instead of having it be a surprise for you later. Okay? Okay. Part 2, I want to talk about risk management. Okay. What are the risks? We've talked a little bit about them, but now we're going to go to some more detail. All right. First risk is the other contract parties will be unable to meet their contract obligations. And that can be for innumerable reasons. It's not that they don't want to do it, it's just that they can't do it. And there's going to be reasons for that. We'll talk a little bit more about them. The other contract parties will be unwilling to meet their contract obligations. They may all of a sudden decide, "I can't afford to do this as for example, I can't afford to do this job for what I said I'd do it for. So I'm just not going to do it." Or, "I'm not going to do it in the way the contract requires me to do it. I'm going to try and substitute some other things. Or I'm going to change the specification a little bit." Or it could be a lot. But for whatever reason, they're unwilling to meet their contract obligations. Or third parties outside of a contracting party's control prevent or delay your efforts to meet it. All right. Sometimes that's called force majeure. Sometimes it's not force majeure. Force majeure being something outside of your control, like weather. But it could be there's a strike. It could be the container ship has gotten stuck in the Suez Canal and a needed part is not going to make it except about 3 weeks after you originally anticipated it was going to arrive. Could be you had a fire. Could be there's been a natural disaster. Could be any one of a number of things where, as willing as I might be to fulfill my obligations under the contract, I can't. It's just impossible for me to do it. And subcontractors or suppliers won't or can't perform their obligations. I may have depended upon a particular subcontractor to deliver some goods to me or some manufactured parts to me. All of a sudden, his assembly line broke down. I'm going to be impacted. What happens under the contract if that happens? Okay. Additional contract performance risks. All right. Work schedule. Can you meet the schedule or can your contractor meet the schedule that's been agreed to? Lots of things can happen that make that schedule to do it. And some of that schedule, and I think I may cover a little bit more, but we'll do is cover it now. Some of it may be that the work that you either agreed to do or the contractors agreed to do or the service has been provided may be something they don't usually do. I'm going to take that big contract because it's a great big break. But then you handle it like you do everything else, and all of a sudden you find you just can't deliver that service in that time to the quality that you've got to do it. The work schedule didn't allow you to do it. You ran into unexpected glitches. So the work schedule may be too tight. Another payment schedule. Cash flow is the real question here. Are you going to have enough money to pay the obligation when it comes due? Whether it's to your suppliers, whether it's to your workmen, or to your contractor who you've got to pay. Next, your ability to pay. Did you just not have the money, and was the money not there? Weather or pandemics. Pandemics we've all suffered. But that's a performance risk. I may be prevented by weather or pandemics from doing the contract as I said I'd do it. Specifications and drawings. We talked about conflicts between the two. If they aren't the same, if they're not complementary, it can create a huge problem. The priority of contract documents. If you say you've got your general terms and conditions, and you've got special terms and conditions, and you've got some specifications and drawings, and you've got some required materials, which takes priority? If there's a conflict between, or you've got a special condition, if you've got a multitude of documents in the contract, somewhere you should say which ones take priority, because guaranteed there's going to be some conflict or discrepancy between them or among them. Inclusion of documents for which no copies are provided. Could be codes and standards, could be a contract that I'm working to, could be a drawing which hasn't yet been done and is scheduled to be given to you. It could be a number of things, and it could have surprises in it. Proprietary or confidential information. You may have it. It may be your information. You want to protect it. You want to make sure whoever you're providing it to recognizes that it's proprietary and confidential and will respect it as such. On the other hand, it could be you're receiving proprietary or confidential information, which means you've undertaken an obligation, sometimes fully described in the contract, of what you have to do to protect the other person's proprietary or confidential information. And that can become expensive depending upon what it is and the requirements for protecting it. The ownership of intellectual property. You're providing a software update. Who owns it? Who owns the program which you're providing? You, who invested all your time, or whoever it is that you're providing it to? That should be clear. You don't want it, if you say you're developing a computer program, an app, you want to make sure that all you're doing is licensing it so that you can continue to license it. You haven't transferred ownership, or you haven't given out someone the right to give out the information about what your app does. The owner, and that goes to the ownership of the intellectual property. You've got to put your pretend. Do you want to protect and maintain ownership of it, or do you want to buy it from your provider? Additional risk, undocumented changes. How many times have you been in a contract where you're trying to bill someone for changes that happened during the performance of the contract? And the comment is, I didn't authorize that change. I didn't want that change. Or I didn't approve it. I'm not going to pay for it. If during the course of the contract, changes to the contract are not documented, even in a series of emails that talk about, yeah, I want to move the cabinet from here to there, and he says, and the contractor says, okay, I can do that, it'll cost you such and such. That at least says what happens. But if he goes ahead and does it, agrees to do it, and then gives you a bill later that talks about how much that change is, you don't have this. That can become a dispute. Either you may refuse to pay him that additional money, or he may have a lien on it, or he may have refused to go further if during the course of it you're not paying, during the course of this performance you're not paying him for the change. All right, laws and codes that get changed. Applicable law, what the jurisdiction is, how disputes are settled. A lot of disputes are now, companies are using arbitration, especially in consumer law. But if it goes to, I had one client who came to me and said, it was a construction company, and she wound up saying, the customer was supposed to put in the foundation. Didn't do it. Now he's going to get to another contractor because I didn't do the work that afterwards, because he didn't provide me the foundation. And it wasn't clear that was what she wanted or what he wanted. There was arbitration, binding arbitration. She lost. It cost her money following what she thought was the contract. So it can come back and bite you. Unusual contract requirements. If you're being asked to do something you don't normally do, be careful and make sure you've provided for unanticipated conditions, unanticipated holdups. You need to know them and provide for them. Is it going to cost you extra money? Is it going to cost you extra time? Is it going to require some skills or new equipment that you hadn't bought? And that equipment may take some time to get there. Make sure that you can meet those unusual contract requirements. It could be simply, it's a far bigger order than you've ever taken before. It's your big break. And all of a sudden you find I can't do that. I can't provide it in the time that I said I would, because wasn't ready to produce it. Warranty obligations. Whether it's written in the contract or not, the law will have warranty obligations. You can sometimes supersede those with written terms. And the warranty obligations include, what do you have to do, or what does your contractor have to do in order to repair something that's defective? What constitutes the defect? How soon it has to be reported in order for it to be corrected? How long the warranty is? How much, what is the correction obligated to do? And do they just have to fix the thing that went wrong, and you assume the rest of the cost? In construction, again, the area I did most, we had what was called in and out costs. Not only did we have to worry about, let's just say, something was in the insulation was wrong, who is going to cover the cost to get to the insulation and then repair the wall or the part afterwards? Is that going to be a customer cost, or is that going to be a contractor cost? Or is it, once it's fixed, is there a new warranty on it, or is it gone? And how long is the warranty period? So there's lots of questions, and if it's important to you to know that in the contract, to find it beforehand, that's a risk you want to cover. And scope of work. You need to know what it is you're going to have to do and what the other person is going to do. It can be a simple detailing of it. It can be as complicated as what's called the division of work and scope of work division of responsibility. And for complicated projects, that can be an important thing. Are you going to deliver materials to me, and when, or do I have to get them? Am I going to get the permits, or are you going to get them? Am I going to deal with your supplier, or are you going to deal with the supplier? All kinds of questions. Fill in the gray areas. Force majeure, things beyond your control, usually weather related, or called acts of God, but it can include things like strikes, acts of war, major events over which you have absolutely no control. Now, how do contracts address risk? Before I switch there, Bill, are there any questions I should address?
No, it's been, everybody's just listening, so
Okay.
keep going.
Okay. How do contracts address risk? They try to account for planned and unanticipated changes to the contract price or schedule. Everything ultimately affects either your contract price or your schedule, your cost, or the value of the contract. It tries to address the performance risks. If, say, you're taking on a task which you haven't done before, maybe you're going to build in extra time to do it. You're not going to do it just in time. Or maybe you want to cover that risk by charging more than what you normally would. Or you may do so by your terms of payment that says you're going to take money sooner than what you normally would, so that you can make sure that you pay or can absorb that risk. All right. Unknowns are treated. Frequently, you never know what you don't know, but you try to anticipate it. Try to identify what the unknowns are. All right. Let me just move this for a minute. All right. Contracts define how the parties allocate the risk of performance. Okay, so what do you have to do? Each of the parties, whether it's one or whether it's five, whether it's in a joint venture that you're agreed you're going to do something with someone else for a third party, each of the parties have to analyze your obligations assumed by yourself and the other parties to the contract. And they have to determine if and how they want to assume the risks. It's always a conscious decision. You can consciously decide to assume all the risk in the world, but you should know you're doing that. In business, that's critical. If you are unhappy with the assumed risks, that the contract or the job looks, then you need to think about, okay, how can it be mitigated? How can I reduce it? How can I make it a little bit less? How can I reallocate it? Can I give my customer or give my contractor a little bit more risk? Or can it be accepted as is? Am I willing to accept the as is? And finally, if you're not willing to do that, should you just walk away? You do not have to accept every contract that's presented to you. And probably if you're a startup, you're going to accept more risk in your contracts than you would once you're established, because you're going to want to do business. But be aware of what risk you're going to do, because and in part you're going to take it because your bargaining power isn't real great, especially if you're dealing with an established company. You're looking to generate some revenue. You're looking to create a reputation, and you're probably going to be a little bit more willing to assume risk that you aren't going to be willing to assume later as you become more established. Now, ways to do it is to mitigate or reallocate risk, negotiate. Almost everything is negotiable. Even those people who say I won't negotiate. Sometimes that's true, but most people are willing to negotiate if you can present something reasonable. Negotiation can be revising the schedule, including float. You can revise the payment schedule. You can cover the risk with insurance. Insurance won't cover everything, but insurance is one way of mitigating your risks. Now, warranty coverage and what remedies are provided for. Another way of covering risk. Limits of liability. First time I've mentioned this. If you can in some way limit your liability, and you'll find it in contracts that you're working, sometimes it's limited to the value of the contract. Sometimes it's limited to the value of insurance recoveries. Sometimes it has a real dollar limit. Sometimes it excludes certain kinds of damages. You may accept full responsibility for direct damages caused directly by the failure, but sometimes what may be excluded are things like indirect damages, consequential damages, I said indirect, special damages, all of which can be monstrous in size, depending upon the harm that's inflicted. So because sometimes, because of your defect, I lost $100,000 worth of business. You're responsible for that. And your contract was only worth $10,000. You're going to try to avoid that. Right. Indemnification. and you've probably seen those clauses. What indemnification is is being made whole for the damages you suffered, for the injury that you suffered. Again, it can be limited. And the extent of who's going to be indemnified. You don't want to indemnify your owner, his other suppliers, his employees, and whatever. You want to indemnify just them. You may, and the same thing with your contractors. All right. The change procedure. What constitutes a change? What defines a change? How's it going to be priced? How's it going to be included in the schedule? All of them are ways to mitigate or reallocate risk. How soon a change has to be identified. How soon it has to be processed. When you have to start work on a change. All of these are ways to mitigate or reallocate risks. And there's more. The dispute procedure. Who's going to decide what, when, and how? Is it arbitration, mediation, courts? Is there a progression of steps? Who gets to appoint the arbitrator or mediator? What law applies? What court will it be tried in? You'll notice frequent people or companies try to have the home court advantage in their jurisdiction. Their local law apply. Specification of drawing revisions, performance and payment bonds can be done. The taking out of liens against the work will help protect, especially in construction. And your price. You may just have to decide you need a higher price to cover the risk. And how much that will be, and you have to be able to explain it. Or and part of that price may simply be contingency. Monies that you don't know where it's going to go, but you know you're going to need it, potentially need it somewhere in the performance of that contract. And you're going to create a contingency. It may be 10%, sometimes as much as 20 or 30%. And scope and responsibility revisions. Who's doing what, when, and where. Or the ultimate one, walk away. In negotiation, it's called a BATNA. And what the BATNA is, the best alternative to a negotiated agreement. When you're sitting and negotiating a contract, when you're trying to make that contract suitable for you and for you to perform, decide what your bottom line is. And if you're being asked, either as a buyer or the seller, to go beyond that bottom line, then you've reached your BATNA. Your best alternative to a negotiated agreement is to walk away. It is the ultimate one, and don't be afraid to walk away. Because of that bad contract may cause you to lose your business. Okay. Now, if you don't understand a contract, if you've tried to read it and you don't understand it, it has something in it doesn't make sense, talk to SCORE or a lawyer or your accountant or someone who's qualified and trusted to help explain it. SCORE is not going to cost you anything. But remember, SCORE will help advise you. We can't draft the contract for you. If you want the firm advice that's going to be, again, it's going to be warranted because they've got professional standards they're going to meet, use a lawyer. Use your accountant to help with redrafting. If you try to draft your own contract, you're going to leave something out. You're not going to account for what the current law is or what the current tax provisions may be. If you try to, and I generally discourage for anything that's even halfway complicated, from going to something like LegalZoom. They're good, or some of the documents that you can find available on the internet. They aren't necessarily tailored for your business, for your circumstances. That lawyer or that accountant is essentially an ounce of prevention. They're that element that will help you understand and account for risk. And now, considerations for a lawyer, assuming you're going to go get one, is remember, first, they're an advisor to you. They'll tell you that, they'll warrant their services, but they aren't the one assuming the risk. They need to help you understand what the risk will be, and they need to be able to advise you on various ways to mitigate that risk or what that risk entails legally, but you're the one assuming the risk. They must answer all your questions to your satisfaction. Don't hire a lawyer who talks down to you. Don't hire a lawyer who obscures the answer or just dances around the question. They're going to be a trusted advisor, and you need to trust them that they're going to answer your questions as fully as they possibly can. They won't hide it. They have to explain it to your satisfaction. Understand their rates and charging practices. Same way you have a schedule of prices, you know what your prices are, you want to know what you're going to pay. Don't be hesitant to ask about what their rates are, the varying rates for things like paralegals, whether they charge for things like secretarial work, what are their charging practices, when do you have to give them money, are you forming an escrow account, whatever it may be. And remember, they work for you. You don't work for them. That first time you talk to the lawyer, when you're interviewing them, if you haven't hired them yet, I generally tell all my clients, you shouldn't pay for that first half hour. That's basically a job interview for the lawyer or for the accountant. They have to satisfy you that they will be able to do the work. Don't expect your problems to necessarily be answered, but it's an interview for them. They're applying to you for a job with you. You are not applying for a job with them. You're going to pay their fees. Okay, quick review. Think about the contract as more than a set of legal terms and conditions. Think about your contract as a work order that tells you what you have to do, what has to be done, and when. Learn how to identify what risks you're taking and how they can be eliminated, mitigated, or accepted. Think about how to make the contract work for you. It's a document that protects you. It defines what it is your obligations are or what you're going to be receiving. And don't hesitate to get help. It can be cost effective. Now, if you want to work with a mentor, go to indianapolis.score.org or score.org and request a mentor. In addition to that, there's a huge amount of reference material you can access from the SCORE website, and there's webinars produced both like this one, produced by the Indianapolis chapter, or they're available nationwide out of the national organization. And that's it.
Hey, great. We have only about 5 minutes left, but let me mention a good question that just came in here in the last minute. What are your thoughts on sampling contracts from other businesses that are like your business? Then they have professional contracts and that they're posted on their website. Is it legal to take those and use them? Would you recommend doing this?
Sure.
Should you have them reviewed by a lawyer? What about all of that?
Okay. Yes, and if you can find contracts in your area of business that others are publicly revealing, and because then it's basically a public document, sure, see what they're doing, see how they're protecting themselves, see how they're sharing the risk. Don't just take it though and replicate it. Think about it, how it applies to what you do and your circumstances and what risk you are willing to assume. Now, if that contract's been written by an attorney, it's been crafted, hopefully, for their client and the risk they're willing to assume. Think about what you're willing to assume. Get it reviewed by, and once you've decided what it is you like and what it is you want to do, yeah, get a lawyer to draft it for you. Because one of the things you can be assured of is you talk to a local attorney, assuming that they're competent, they will know what local laws apply. Depending upon what your business is, try to find someone who's got experience in that business line, who's done contracts, drafted contracts, worked for, say, a clothing manufacturer or an intellectual or a computer company or a software company or a construction company or the entertainment business or even the food business, that they've got a familiarity with it so that they know what laws apply and what does or does not work, and help you evaluate the risks.
Okay, Ed, so here's the last question. I've seen a lot of contracts that have all of what you've mentioned in them, but there's a lot of them that don't have every element that you mentioned. And one of the things you mentioned is indicating how it's going to be arbitrated or what jurisdiction it's going to be in.
Mm-hmm.
But what if the contract is silent to all of that? It's just a contract. It never says if something goes wrong, here's what's going to happen. How do people get justice? You hear people say all the time, well, I'll sue you. What does that mean? How does that happen?
Assuming that there's nothing illegal in the contract or nothing very contrary to public policy, if the contract doesn't mention it, the general law of the applicable jurisdiction will apply. So it says if you're suing someone, precedents, local law, state law, even federal law will be referenced.
So what do? Do you walk down to the courthouse and sign up for a session in the court? I mean, what's the actual process
of suing?
Yes.
So unless it's going to be a small claim, which you can do yourself without a lawyer, you need to go to a lawyer. You need to go to a lawyer, have them assess your claim, because it may well be that the cost of settling that claim or settling that dispute is more than it's worth.
Okay.
And if you try to prosecute your own claim in court, you've got a problem, because you just don't know the rules of it. It's like walking onto a pro football field and you're a high school player. You just don't know the rules of the game. It's
Good.
played at a level you're not used to.
Well, we're going to stop it there. It's been a good hour and a half, lots and lots of information. Want to remind everybody that we're going to send you a email message after this. It'll have a link to the telephone ring. It'll have a link to the video of this. It'll have a copy of the slides, and Ed is also sending you a one-page document on how to go about finding a lawyer and using a lawyer. So a lot of good information coming your way. Thanks for joining us, and I'm signing off.
All right.
Thanks,
Thank you,
Ed.
everybody, for joining.
Okay. Bye, everyone.